Well, hi, everyone. Either good morning or good afternoon, depending on your location. Welcome to the next in the series of our labor, employment, and human rights webinars. This one is Navigating Workplace Investigations in an Evolving Environment, Ensuring Fairness and Reviewing Current Developments. My name is Sarah Graves. I'm a partner at Fasken's Toronto office in the Labor, Employment, and Human Rights group. Before I introduce my colleagues who are on the panel with us today, I wanted to just draw your attention to the administrative information outlined on the screen, and in particular, the QR code and links that will be available at the end of the event so that you can get your Ontario, Quebec, or BC CPD certificate. And we'd also really appreciate it if you would fill out the survey as well, because we really value your input, topics that you're interested in, and your feedback on today's seminar. So joining me today, I have two colleagues, one from our Ottawa office and one from our Toronto office. So first is Judith Parisien. She is a partner in the Labor and Employment Group in our Ottawa office and has a broad practice that encompasses all areas of labor and employment law. I'm also joined by Rebecca Rossi, who's an associate in our Toronto office. She also has a very broad practice that covers all aspects of labor, employment, and human rights law. All of us together have considerable experience dealing with investigations, either advising clients who are conducting investigations, addressing issues around investigations that arise in litigation, or conducting investigations ourselves as independent third parties. And as I always say, the only people who think investigations are easy are people who do not conduct investigations, because we know they're challenging. And so we are really pleased that you're joining us today to discuss some of the issues that we're seeing that are challenging in today's environment. So in this presentation, we are continuing our webinar series that deal with investigations. And as I said, some of the challenging issues we're all facing. So the topics that we plan to cover today are really a combination of, as I said, the issues that we're seeing that are coming up both in the investigations that our clients are conducting and the ones that we ourselves are conducting. We've also got some interesting updates for you in terms of case law developments, ones that we wanted to bring to your attention. And then because it's increasingly becoming a topic of conversation, we want to address, just as in an introductory manner, the idea of artificial intelligence and how it can be used in investigations. So if we take a quick look at our agenda, we're going to deal with the issue of procedural fairness and best practices, and Judith will lead us through that discussion. Then we'll hand things over to Rebecca, who's really going to talk about integrating DEI principles into our investigation, because that continues to be important. And we'll address topics as how to avoid bias or myths or stereotypes impacting our investigations when we're reaching our conclusions. Then I will speak briefly about the role of power dynamics and their impact in investigations, and how we as investigators have to take those into consideration when we're reaching our conclusions. And then lastly, as I said, we will address the idea of workplace investigations and how artificial intelligence could be used to assist, but also what are some of the dangers that we face there. So I want to start by just spending a very few minutes on some basic principles that underlie the investigations that we all conduct. Sorry, I advanced that too quickly. So it's important from time to time, regularly to revisit, why are investigations important? Why do we spend all the time and resources doing these investigations? One of the main reasons, as we all know, is to ensure workplace compliance with applicable laws. We also want to identify areas of concern that the employer needs to address, and that will make sure that our employees really view the relationship as one with trust. They'll have confidence within the organization that we will address problems that they are facing. And the most important reason is to create and maintain a strong and positive work environment. Employees, when they feel that their concerns are being addressed, being taken seriously, and handled appropriately in connection with all our other HR processes, will really go a long way to creating that strong and positive work environment that we all want, and to ensure that any issues that may be bubbling up or arising in a workplace, we will get to address them early on, because people will have the confidence to bring forward their complaint at the earliest possible stage where we can address it, where hopefully it's a more minor issue. So just as a refresher, there are human rights legislation obligations to create investigations, right? Human rights legislation provides that we have a duty as employers to provide a discrimination-free workplace. Occupational health and safety legislation in many jurisdictions contains provisions that deal with workplace violence and harassment policies and programs and require investigations. And that is part of the reflection of the fact that harassment is no longer viewed as just or only a discrimination issue, but it's also a safety issue. And then also we need to do investigations where we're considering discipline, especially termination of employment for just cause. And that could be where there's policy violations, compliance issues, or criminal or regulatory wrongdoing. So when we were considering the content for today, one of the sort of foundational issues that we're finding coming up with our clients lately is this idea about whether a formal complaint is required. Many policies will require bringing forward complaints using various resources that are available to receive those complaints, or will require a particular form to be completed. But as we all know, a formal complaint is not required to trigger an employer's duty to investigate. As I mentioned, under human rights law, there is a duty to ensure that we have a discrimination-free workplace. And also, occupational health and safety legislation often requires investigations. And in Ontario, for example, it's not just complaints where an investigation is required, but also incidents. So once we are aware, once the employer becomes aware of an incident, then that duty to investigate is triggered. And that includes circumstances, for example, when an employee comes to a manager and says, I just want to tell you about something that happened, but I don't want you to do anything about it. Our duty as employers are triggered then, and that's why we conduct training of our managers so that they know how to respond in that circumstance. And it's also why our policies typically have a requirement that employees who are aware of, who witness, or have learned about potential conduct that would violate our policy, our harassment policy, for example, are required to bring forward their concern. What we're seeing sometimes is a tension between the legal requirements and policies that provide for an informal resolution. And sometimes the informal resolution process, which is often preferred in certain circumstances, can come back in certain circumstances to the employer. And that can be either in a litigation or in a demand letter. So, for example, we'll see allegations in a case where there was termination, allegations of retaliation. We'll also see in either the litigation or a demand letter allegations that a person was forced to or felt pressure to engage in an informal process. And then we're also seeing instances where the use of the informal process without more is basically being determined as not satisfying our requirements under rules that require investigation. And so an example of how that might come up is you have an employee who complains to a supervisor, for example, that Joe made a sexually harassing statement to them. The supervisor who hears that concern tells HR, and then HR says to the employee, I'll look into it. But then HR decides to deal with it informally because there is an informal process under their policy, but doesn't discuss that with the employee. HR then speaks to Joe, who's alleged to have made sexually harassing comment, and he apologizes, recognizes he shouldn't have done it, and says, "I won't do it again." And no one gets back to the employee who raised the concern. So in a circumstance like that, we don't know, for example, if the employee consented to that informal approach. We don't know whether the HR department here considered whether that was appropriate in their particular jurisdiction. Are they in Ontario, for example, where an appropriate investigation is required when you have knowledge of one of these circumstances? And if it is in such a jurisdiction, is this a sufficient investigation? And here it would be problematic because no one has gotten back to the employee who raised the concern. So there are many instances where informal resolution of complaints is appropriate and often preferred. But when you're thinking about using those types of policies and procedures, make sure you check your policy first to understand when it's appropriate and if consent is required, which we would recommend. Make sure it's consistent with the applicable law in your jurisdiction, and then appropriately document that process so that if after the fact there's some question about the use of the informal process, you have some information that documents what happened, consents, how the matter was resolved, for example, and notes that were taken during that process. So with that foundational issue, I'm going to turn it over to Judith, who's going to discuss procedural fairness.
Thank you, Sarah. All right, so now we've discussed why investigations are important. We're going to turn to how investigations should be conducted. And although many investigators have different styles, they have different approaches, I think we can all agree that any appropriate workplace investigation at a minimum has to ensure that procedural fairness is really the driving force of the process. So the specific requirements of that procedural fairness are different depending on the circumstances. But at its core, you want to think of 4 main requirements. The first of them is the requirement of notice. So both parties must be notified that an investigation is taking place. And after having carefully considered the complainant's allegations, the respondent must be notified, obviously, of the allegations against them. The second is the requirement of the opportunity to be heard. So again, both parties must be given a fair opportunity to provide their position to the investigator and to respond to information provided by the other side and by witnesses. This also means that once the investigator has received that information from the parties, from the witnesses, the investigator has to genuinely and carefully consider that information and evidence when they're making their decision and preparing their report. The next requirement is objectivity. So naturally, it's necessary for us as investigators to be impartial, to operate without bias. This is true both in terms of being and being seen to be impartial. And when we're considering biases, we want to be specifically aware of our own unconscious biases. And Rebecca's going to tell us a little bit more about that in a moment. And your final and fourth requirement in terms of procedural fairness, we're dealing with confidentiality. We all know that these processes and these investigations must be confidential. We shouldn't be disclosing information about the complaint unless it's necessary to protect the employees, but of course also necessary to have a thorough investigation and to take corrective action. So let's look at some of the common errors that we see in workplace investigations. This is a list that actually comes from a 2020 case in Saskatchewan. Some of them are somewhat kind of related to the same theme, but I want to go through them with you. And the first one is rushing to judgment before obtaining the facts. This risk is especially live, I find, in the context of investigations that are done internally. In those cases, the investigators already have at least some sort of knowledge of the parties who are involved, the workplace, maybe even some of the interactions. And they may be inclined to kind of rush to a conclusion about how they think their investigation is going to finish, or what conclusion they're going to come up with at the end. So really what we need to remember is, from beginning to end, really approaching the information, the meetings, the documentary evidence in an objective and neutral manner. We look at the other ones. There's the failure to be transparent or honest with the investigated employee during the investigation process, failure to provide, it says, particulars, and I'll say sufficient particulars of allegations to an employee under investigation, failing to provide the employee under investigation with an adequate opportunity to explain and respond. We saw that as a driving force of procedural fairness. Failing to consider an investigated employee's response. So you you receive the information, but you fail to consider it, for example, in reaching your conclusions in the report. Failing to put potentially relevant information to witnesses. So this is about testing the story, right? You're receiving evidence from the complainant, from the respondent, and it may be that in order to test the story a little bit more, you need to take that information and go ask some witnesses that may have also been exposed to the conduct. And finally, failing to consider other evidence, computer records, emails, text messages that may be relevant to the investigation. So from my perspective, when we're looking at these common errors, I find that when we see these errors, generally they come from a good place. And oftentimes where they come from really is this balancing act that we all do as investigators in trying to determine, how do we balance confidentiality and only sharing what needs to be shared with this opportunity to be heard and really provide a full and complete response. So these are really cornerstones of what you are doing when you're doing your workplace investigations. And what we're going to see shortly in the two cases that I want to discuss with you is really considering this fair opportunity to be heard, not only from the respondent's perspective, but also from the complainant's perspective. But before we do that, let's look at what can happen in terms of consequences if the investigation that we've done is considered to be unfair. So the ultimate risk, obviously, is that it's going to be deemed to be inadequate by a court, by a tribunal, by an arbitrator. And if that occurs, the decision maker could set aside some sanctions imposed by the employer. So think of an employer who relied on an investigation report to terminate the employment of an employee. That will be at risk if the foundational reason for the termination was an unfair investigation. There could also be an order that the investigation be redone completely or even partially at a cost for the employer. And there could be some damages ordered to be paid in terms of compensating the employee for lost wages, stress, loss of reputation, or other losses that could stem from the lack of procedural or substantive fairness. So let's look at the cases there are two cases, recent cases from 2024. They both come from the Federal Court of Canada. The first one here is Marintet versus the Attorney General of Canada. And in this case, the federal court reviewed an investigation that was performed pursuant to the workplace harassment and violence prevention regulations, which regulate federal employers and employees and really set out specific requirements for your workplace harassment and violence investigations. There was a Canadian Border Services officer that filed a complaint alleging 7 incidents of workplace harassment and violence involving 6 different supervisors. He alleged that he was subject to a pattern of workplace violence and harassment behavior at the CBSA, and really provided various examples of that conduct. An investigation was conducted under the employer's workplace harassment and violence prevention program. Notably, this particular employer had its own workplace harassment violence prevention regulations checklist. And the checklist was quite detailed in terms of setting out the different steps that needed to be conducted in the context of the investigation. So the investigator performed the investigation and issued a 12-page report. The investigator did not ask the applicant in the course of the investigation about the evidence that was collected from the respondents and the one witness that had been interviewed. The investigator also did not provide the applicant with an opportunity to respond to this evidence, and that was contrary to the checklist. The checklist of investigation steps in this case specifically set out that there was a copy of the investigator's preliminary report that needed to be given to both parties. Both parties would then have the opportunity to consider the preliminary report and provide comments on it. And the court in this case found that none of those steps had been followed by the investigator. The report found that none of the 7 incidents amounted to harassment or violence, and the employer adopted those findings in the investigation report. The complainant then filed for judicial review to set aside the report. So the federal court granted the application for judicial review for this employee, finding that the investigation process that led to the decision raised significant procedural fairness concerns. In reaching his decisions, the judge noted, and I quote, that workplace harassment and violence investigations are afforded a high level of procedural fairness. In this case, the respondent had tried to argue that this high level or elevated duty of procedural fairness only applied to the respondents and not the complainant. The court disagreed, and the judge noted that by failing to provide the complainant with the opportunity to respond to the evidence that was contrary to his allegations, this is another quote, it seems the applicant was expected by his complaint and in his single interview with the investigator to have comprehensively addressed not only all issues he raised, but also to have comprehensively anticipated and addressed all of what the responding parties and witnesses might tell the investigator. So that was in terms of not the investigator hearing new information and not going back to the complainant to get their version of events on it. The court also noted the failure to follow the employer's own checklist, again, with respect to providing the preliminary report and getting the comments on it. So if we look at key takeaways from this decision, it really does confirm and highlight that a complainant, just like a respondent, has a right to know and respond to evidence that's contrary to their allegations. So a complainant must be given a full and fair chance to be informed of any prejudicial facts and the right to respond to those facts. This is essentially considering whether the complainant should be given the opportunity to have a reply interview or provide reply evidence to new matters that arise from the respondent and the witnesses, and that really are central to the determination of the subject matter of the investigation. So this is not to say that as investigators, all of our investigations are necessarily going to entail multiple interviews with all of the parties. But what we have to remember is that before we render a decision and write the report, we need to ensure that key prejudicial facts are put to the other party before moving ahead with the conclusion. So let's look at this next decision. Second here. Whoops. What? Oh, Here we go. My apologies. So the next case is Whitelaw versus Canada Attorney General and the RCMP. Here, the applicant is a retired RCMP officer who brought two different human rights complaints against the RCMP, one of which alleged a retaliation stemming from events that surrounded a traffic stop, essentially. So in this case, we don't have a typical workplace investigation. What we have is the Canadian Human Rights Commission conducting an investigation into the human rights complaint and dismissing the complaint of retaliation. So here the applicant sought judicial review of that decision, and in doing so raised some issues of procedural fairness, suggesting that the investigator was biased and had failed to provide evidence to her. So if we look specifically at what she alleged that the investigator did not interview the witnesses that she had suggested be interviewed, was close-minded and appeared to have made a predetermination about her complaint, did not ask sufficient questions during her interview, and did not provide her with certain evidence that was relied upon in the conclusion to dismiss the complaint. So here the federal court found that the investigation was not procedurally unfair and there was no evidence of bias. So in response to the applicant's specific concerns, the court noted that in this case, the investigator had indicated in their report why they didn't interview the witnesses that were proposed by the applicant. And in fact, that was because the applicant herself had noted that those witnesses had no direct knowledge of the allegations. The court also noted that the assertions of bias were speculative in that case, and that suspicion of bias alone is not enough, given that there's really a high threshold to demonstrate bias. In response to the concerns about the sufficiency, when she was saying that the investigator didn't ask enough questions, there was an interesting quote that stated, "Investigators have a wide latitude. They are not required to turn over every stone, nor can they be held to a standard of perfection." The court also found that it was not unfair in this case for the investigator not to have shared all of the materials that had passed through their hands during the investigation. So if we take a step back and look, because the court made some more general kind of high level comments about principles when making decisions about procedural fairness. And here the court noted that really what the reviewing court's job is to ask whether a fair and just process was followed, right? What they need to consider is, did the applicant know the case to meet and have a full and fair chance to respond? So again, going back to those basics, right? And what the court also noted was that administrative decision makers are not expected to respond to all arguments or lines of possible analysis, but they are expected to contend with central arguments and issues. So what we have here are two different decisions from the federal court, one where the investigation was found to be procedurally fair, the other where it was procedurally flawed. So where does that take us in terms of best practices? Really, there's several practical steps and takeaways that we can gather from these cases in terms of combating perceptions of procedural fairness in our investigations. The first is, when in doubt, we need to ask ourselves, what are we really investigating here? What is the crux of the case? We need to get a clear understanding of what happened before, during, and after the incidents. Because and as Sarah mentioned at the beginning, anybody who thinks that these things are easy is because they haven't done them in the end. It really is easy to get lost into the weeds of some of the allegations that are brought forward and some of the details. But circling back to the core issues that we're really trying to opine on can really help us stay on track. So the second thing we need to do in terms of best practices is ask ourselves if both parties had a full opportunity to respond. If not, we need to consider some further or reply interviews. So if we see that we heard an allegation A from the complainant, we go to the respondent, and the respondent, for example, says, the day that the complainant says that I harassed them, I wasn't in the office that day, right? Well, what would the complainant have to say about that? Is there a reason in that case to go back and ask the complainant and put that statement to the complainant? So again, consider whether reply interviews are interesting. Then document everything. I made a note, right? Sarah just talked about documenting our process in terms of the informal process that may be followed. But of course, this also applies to the actual process of the investigation. And it's going to demonstrate what we considered in terms of the issues that came up. And what we chose to do and chose not to do. Remember the case we just looked at in Whitelaw, the court there relied on the statement in the report of why the witnesses were not interviewed. And that helped in terms of establishing that the process was fair. By having clear passages that are written down in the report in terms of what we are relying on in terms of relevant documentary evidence, that can also help the reader, not only that's going to read it at the beginning, the employer receiving the report, but perhaps an arbitrator or a court looking at it down the road. And it's going to help them better understand what was considered and why the decisions were made. The fourth here is know and follow investigation policies and procedures. And I cannot stress this enough. If you're conducting investigations internally, maybe you know the policies by heart, but maybe it's been changed recently, or maybe you haven't looked at it in a while. And so just a reminder, when we look at the Marintet case where there was a specific step that was provided for, that may not be required in all investigation processes, but that was chosen by the employer as a step that would be followed. So if there's a specific step in a policy or a procedure, making sure that those steps are followed. That, of course, is especially true as well for external investigators going in who may not be familiar with the different policies of the clients. And so making sure that those are carefully considered when looking at the process. And then finally, we really need to demonstrate our neutrality by treating all the parties that we're meeting with in a similar manner. And again, documenting that approach can be helpful. In the Whitelaw case, in terms of the questioning of the witnesses, it was noted that the investigator had not only not interviewed the witnesses proposed by the complainant, but also not interviewed the witnesses provided by the respondent. So no two cases are going to be the same. What's required in each case, each investigation is really different depending on the circumstances. There was another quote from Whitelaw that we thought was interesting. And this is, I quote, Supreme Court of Canada. The Supreme Court of Canada observes that the duty of procedural fairness is eminently variable, inherently flexible, and context specific. So again, no right answer in all cases, but if you go back to those four requirements that we discussed, the notice, the opportunity to be heard, the neutrality, and the confidentiality, then you're likely to be well on your way to having an investigation that is procedurally fair. So I'm going to turn it over to Rebecca to discuss some DEI principles in your investigations.
Thank you, Judith. So in this section of the PowerPoint, I really want to focus on the topic of integrating diversity, equity, and inclusion principles in workplace investigations. And of course, Judith just focused on the importance of procedural fairness in investigations. And so related to the concept of procedural fairness and ensuring procedural fairness. As I will explain, DEI considerations are crucial in workplace investigations. We can see from trends in recent studies that have been conducted that discrimination and harassment remain significant concerns in Canadian workplaces. And so, for example, there was a recent report published by the Future Skills Center in conjunction with a few other organizations titled Experiences of Discrimination at Work. And that was a study conducted between December 2020 and January 2021. And it found, among other things, that 3 in 10 women, for example, experience gender-based discrimination at work. 2 in 5 racialized employees experience race-based discrimination in the workplace, which increases to 1 in 2 for Black employees. And 1 in 4 employees with disabilities experience discrimination at work. And those are just a few of many other statistics that were found. But given these findings, it's no surprise that we see that workplace complaints are on the rise, which results in an increased need for investigations, of course, for those in HR or us who conduct investigations. So that is why it's particularly important to consider the ways in which we can integrate DEI principles, not only in our workplaces, but also in the investigation process to create a more fair and respectful workplace and process. So there has been much ado recently about DEI, but I think what's important to emphasize here is that the acronym DEI, it's more than just buzzwords. They're essential principles aimed at driving fairness and respect in the workplace. And so in thinking about DEI, it's important to think about the meaning of the words that make up the bundled acronym DEI. And so briefly, D obviously stands for diversity, which involves acknowledging and valuing differences of all of the ways that people are different, including in the workplace, such as the characteristics that distinguish individuals from one another. And it often refers to including demographics that aren't broadly represented in society or certain industries, such as considerations about individuals' race, gender, age, sexual orientation, and so on. However, diversity can also include the range of ideas, perspectives, and values that individuals have and hold. Very briefly, E refers to equity. Equity aims to ensure equal treatment, access, opportunity, and advancement for people, including employees in the workplace. And it aims or attempts to identify and remove barriers that prevent some groups from fully participating in the workplace. And finally, I stands for inclusion. Inclusion is about creating an environment where everyone feels valued and accepted. And it's a culture or setting that actively invites individuals or groups to contribute and participate, and also embraces differences. So when conducting workplace investigations, it's crucial to integrate DEI principles to avoid reinforcing systemic biases and to foster an environment of trust. DEI considerations help ensure that the investigation process does not disproportionately impact certain marginalized groups and that all voices are heard and valued, specifically when we're driving at getting at the truth. What we want is to foster a process that ensures that individuals trust so that they feel that they can speak openly and honestly. And so in order to integrate DEI principles in investigations, we want to ensure that we're being mindful of cultural differences, different communication styles, potential power dynamics that can influence evidence, but also the investigation outcome. And so this is what I'll briefly talk about in this next few slides. So how can we implement DEI techniques in our investigations? So in this slide and the next, I've included some ideas or some techniques that we can think about, but I'll note that these techniques reflect the greater themes that we will be ultimately discussing throughout this presentation, which include procedural fairness, which could include bias, could also include challenging myths and stereotypes. And so while these are just a few techniques, we'll continue to discuss this throughout the presentation. So the first technique I wanted to highlight is recognizing and mitigating bias. So biases, whether conscious or unconscious, can significantly impact the fairness of workplace investigations. And so it's essential to recognize and mitigate these biases to ensure that there is ultimately a just investigation process. I will hone in on the topic of recognizing and mitigating bias in the next section of this presentation, so I'll hold on this. But the point I want to highlight right now is that ignorance is not bliss. We want to be aware of our biases, and we want to ensure that we're actively working on counteracting these biases in order to mitigate the impact of them throughout the investigation process and as we're making findings. The second technique I wanted to highlight is that in order to ensure fairness, we as investigators need to ensure that we're ensuring fairness in the gathering and evaluation stage of evidence. And we want to do that in a DEI-sensitive manner. So what does that mean? Ultimately, what it means is that when we gather and evaluate evidence, we want to be mindful of how and from whom that information is being collected. What we want to ensure is that we're fostering a safe and supportive environment, not only for complaints to be brought forward, but also for parties that are involved in the investigation process, whether it be the complainant or the respondent or witnesses, to share their experiences without fear of judgment or retaliation. And so that could involve at the outset, from a policy perspective, having procedures in place, such as systems that enable individuals to make anonymous reports or to make different levels of reporting, so that ensures that complaints are being made in the first place. But it may also involve that during the investigation process, that interview settings are comfortable and not intimidating. Ultimately, what we want is that parties feel comfortable to divulge information that is relevant to the complaint. Turning to the evaluation of evidence, it's important for investigators to consider the context and potential cultural factors that might influence behavior and perception. So, for example, as we know, communication styles can vary widely across individuals. And so what one person may deem as aggressive in one circumstance might in another circumstance be perceived as assertive. And so we want to consider context, and we want to consider the nuances that can prevent misinterpretations when we're evaluating evidence, and ensure ultimately a fair assessment of that evidence when we are reaching conclusions. The third technique to highlight is that in order to integrate DEI principles in the investigation process, we want to ensure that at all times we're ensuring equity. Equity can mean many things in the investigation process, but what we want to highlight is that we're treating all parties with fairness and impartiality. And so Judith actually touched on a lot of this in the procedural fairness section, but that could include, of course, providing equal opportunities for all individuals involved in an investigation to present their side of the story, and ensuring their evidence is provided due consideration. And it's also important to be transparent about the investigation process and the criteria used to evaluate evidence so that individuals involved understand ultimately how decisions will be made. Sometimes in law, we often think about the case we need to meet. And so we want participants to also be able to fully understand the process and how findings will be reached so that they have a fair opportunity to share their perspective or share their own version of an event. Additionally, we also want to ensure we're offering resources, perhaps that might be an employee assistance program, that can also help ensure that parties have the support they need during the investigation so that they can equitably contribute to it. And a final technique to consider as an investigator is inclusion and communication. Communication is the cornerstone of an inclusive workplace investigation, and that involves not only being a good listener and listening to all of the parties that are involved, but ensuring that they also feel heard and understood. Inclusive communication requires sensitivity to language barriers, cultural differences, and varying levels of comfort with the investigative process. But it can also involve providing regular updates to involved parties, or maybe advising them that there won't be an update to provide transparency. And it's also important to communicate the outcome of the investigation clearly and respectfully to those who need to know. And also to ensure that all parties understand the reasoning behind decisions. Ultimately, what the purpose of being transparent does is that it reinforces the organization's commitment to DEI, but can also contribute to a more trustworthy work environment, not only in the investigation process, but also more generally in the workplace, in terms of an organization's responsibilities to investigating and looking into complaints. I'm now going to switch gears and hone in on the topic of recognizing and mitigating bias. As I had noted earlier, recognizing and mitigating bias is a key way to integrate DEI principles in the investigative process, but also to more generally ensure fairness and procedural fairness. So I'm going to briefly go over the basics of what bias is, but also how we as investigators can avoid it. So it's widely acknowledged that we as humans are all biased, and bias is not necessarily always a bad thing. However, being able to recognize biases is often key to ensuring that we're not making unfavorable decisions as a result of the influence of that bias. And so what is bias? Biases are opinions that we form based on various factors that could include our own personal experiences, what we hear from others, it could be institutional influences, and even our culture and our upbringing. There are two main types of bias, and that includes explicit bias or implicit or an unconscious bias. So explicit bias is a type of bias that refers to attitudes or beliefs that we may consciously endorse or openly express. And this tends to be a more obvious form of bias or unfair treatment. So for example, in the context of a workplace investigation, an investigator may ask a leading question that may reflect their bias. So for example, if they were to ask in the same process, a male employee, how do you manage your team effectively? While asking a female employee, how do you balance work and family responsibilities? That differential questioning or line of questioning reveals an explicit bias regarding gender roles. On the other hand, implicit bias refers to attitudes or stereotypes that affect understanding, actions, and decisions unconsciously. So it may be the result of past experiences, expectations, or stereotypes that form an opinion in your mind that you're unaware of. It's involuntary. So for example, in the similar context of a workplace investigation, this could be displayed by an investigator paying more attention to negative behaviors exhibited by employees from one demographic while overlooking similar behaviors in others, influenced by their implicit biases. So I think I covered this off, but I just wanted to hammer home the point that unconscious bias is an implicit attitude or motivation. It's unintentional. And if an investigator is not actively paying attention to that bias, they may be unaware that they are making biased assumptions or stereotypes, which is why it's important to understand both how to recognize your own biases, but deal with them head on during the investigation process. So on this slide, there's just a few different types of unconscious biases that we wanted to highlight. And just to briefly maybe touch upon a few of them. So affinity bias, this occurs when individuals favor those who are similar to themselves in some way, whether it be background, interest, demographics. There's beauty bias, which refers to the tendency to favor individuals who are perceived as more attractive, often leading to preferential treatment. Perception bias. This may occur when an investigator's preconceived notions or stereotypes influence their interpretation of events or behaviors. So, for example, if an investigator perhaps had the belief that younger employees are less responsible, then they may interpret some fact evidence about a late project submission by a young employee as a sign of incompetence, while viewing a similar situation involving perhaps an older employee as a mere oversight. And so that can lead to inconsistent evaluations of performance in a single investigation. There's confirmation bias, and there's also the halo horns effect. So halo effect occurs when a positive impression of a person in one area influences opinions in other areas, whereas the horns effect is the opposite. So a negative impression in one area affects overall perception. And so maybe by way of example, if an investigator has a favorable view of an employee, again, due to their strong performance on previous projects, then they may overlook or minimize any misconduct allegations against that employee in other circumstances. And conversely, if the same investigator has a negative impression of an employee due to past mistakes, they may be more likely to believe allegations of misconduct against that same employee without considering context or evidence. And so the purpose of this slide is just to be mindful of the various ways in which unconscious bias might occur, understanding that it's not deliberate, but you want to be aware of it so that you are ensuring that you're treating individuals fairly at all steps of the investigation process. And there is, in the next slide, I will address a recent Ontario Divisional Court decision that involved the issue of bias, and that's AMA-PCEO and the Ministry of the Attorney General's Office. And so briefly, the facts in that case include that a complainant who identified as Black alleged that her white colleague intentionally shoved her when they were passing each other in the workplace. A white male investigator was assigned to investigate the complaint, and he did not ultimately substantiate the complainant's allegations. Interestingly, in his findings, the investigator stated that the complainant's evidence seemed contrived. And I quote from the investigation report, he wrote, "seems calculated to lead to the requested relief, including compensation." And in his report, he also didn't include statements by any of the witnesses. And he incorrectly stated that one witness called the complainant's tone threatening, when in fact that witness had actually used the word confrontational. So there was using different terms, wasn't accurately representing the evidence. So the complainant's union filed a grievance and challenged the investigator's process and conclusion, and stated that the investigation itself was discriminatory and bore the hallmarks of anti-Black stereotypes, prejudice, and implicit bias. And at the arbitration, the union called an expert witness to testify about the concept of unconscious bias and to explain common anti-Black stereotypes. Ultimately, the arbitrator concluded that while the investigation was not fair or unbiased, the arbitrator also found that it wasn't discriminatory. And the arbitrator said that while racism was one possible reason for the unfair investigation, it was not the dominant possibility, and therefore there couldn't have been discrimination. So in particular, this is a quote from the arbitrator's decision. Is that, "in my view, in order to find that the investigator was unconsciously biased against the griever due to her race, there must be actual evidence apart from the statistics to suggest bias. There must be words or conduct which, on a balance of probabilities, lead to the conclusion that such bias was present and affected conduct." And so the union in the circumstances had applied for judicial review of the arbitrator's decision. And upon judicial review of the decision, the divisional court found that the arbitrator had incorrectly applied the test to assess prima facie discrimination under the Ontario Human Rights Code and otherwise erred in several ways. And the court ultimately granted the application of judicial review and remitted the matter back to arbitration. In doing so, the divisional court highlighted the issue of unconscious bias and the arbitrator's consideration of unconscious bias in the decision. And in particular, the divisional court found that the arbitrator discounted expert evidence about unconscious bias, stating that there had to be actual evidence to suggest bias when that's not required. That's not the test. And the arbitrator also failed to recognize the correlation between his own findings and the expert evidence concerning the indicia of unconscious bias. So, for example, some of the arbitrator's findings included as follows. So they found that the evidence of the griever ought to have been given more consideration by the investigator, and that had he done so, he surely might have thought implausible that the griever would cook up a scheme on the spot to make a false claim in order to seek compensation. And the arbitrator also said the investigator's finding that the griever made up the complaint for compensation was particularly harsh and not based on actual evidence. Other examples of the arbitrator's findings included that he found that the investigator was not tasked with investigating the motives behind the griever's complaint, and yet for some reason he took it upon himself to draw such conclusions. He found that the suggestion that the griever was making the complaint in order to get money was never put to the griever and was not suggested by the respondent or even any of the witnesses. It was only suggested by the investigator himself. And finally, had the griever been given an opportunity to respond to the investigator's claim, he would have realized the basis for his suspicion was illusory, and that the investigator's failure to ask the griever to respond to the investigator's own theories was improper and deeply unfair. And so, in brief, the decision highlights multiple issues, but to address two, it first reminds us of the importance of using the correct tests when determining whether there has been a breach of policy or legislation, accurately and thoroughly reporting on the evidence of the parties and witnesses, and avoiding off-mandate speculation about complainants or providing unsupported justifications for the actions of those alleged to have engaged in discriminatory behavior. And it also illustrates the pervasiveness of unconscious bias. So not only does the investigator's findings demonstrate unconscious bias, but even the arbitrator, we see that in his own findings, while he's suspicious and believes that there might be bias or discrimination, he discounts that evidence. And that's what the divisional court is really touching on in this decision. So finally, this is just a reminder about some of the themes to date in this section of the presentation about unconscious bias. So in order to avoid unconscious bias, make sure you're honest with yourself. Consider whether you have unconscious bias and challenge those assumptions. Avoid snap judgments in the investigative process, and make sure you're basing decisions on facts and observations. And also keep an open mind, remembering those DEI principles. So that means considering context and potential factors that might influence behavior and the perceptions of all involved parties in an investigation. So I'm now going to turn the mic over to my colleague, Judith, who I believe will be discussing the topic of challenging myths and stereotypes.
Thank you, Rebecca. Yes, so in addition to avoiding unconscious bias, or at least being aware of it, there's also several outdated myths and stereotypes that we need to avoid in conducting our fair workplace investigations. So we've included a few on the slide here that we can go through. And the first is only women are harassed and only men are harassers. To the contrary, anyone, regardless of their gender, can be the victim of harassment or can be the harasser. And when we're listening to the witness and the party's evidence and trying to determine what occurred, was there workplace harassment, we need to be careful in making sure that we're not perpetuating that would make us for example, find that a man that alleging that he was harassed would be less credible because of his gender. The second one is if she or he didn't complain, then it's not harassment. Harassment is harassment, even if a formal complaint was not made. Sarah has discussed it in her introduction, and we're going to shortly look at a decision which also confirms this conclusion. So obviously, some victims can be afraid to file a complaint, especially when the harasser is their boss, and they could be concerned about reprisal. So another myth or stereotype is it was a compliment, it was a joke, so it can't be harassment. Of course, even when a person intends their conduct to be flattering or funny, it can still be offensive to others. And although intention could be relevant to the corrective measures that are going to be put in place by the employer, it certainly does not impact whether harassment actually occurred or not. And then the last one is the behavior must be repeated in order to be sexual harassment. It only happened once. Ergo, it is not sexual harassment. Sexual harassment can, of course, consist of repeated actions. And in some jurisdictions, the occupational health and safety legislation actually refers to engage in a course of vexatious comment or conduct. But what we need to remember always is that harassment can also arise from a single incident that was sufficiently egregious or serious. So many of you will have heard about the Metrolinx case. It's been around for a little while. What is exciting for us today to share with you is that the Court of Appeal has just rendered its decision, long-awaited decision, just a couple of weeks ago. But before we get to the decision of the Court of Appeal, let's look a little bit at the background and the divisional court decision. So here, back in April of 2020, while the Human Resources Department of Metrolinx was investigating an unrelated matter, there was an employee that informed the employer about a WhatsApp conversation between the 5 grievers that occurred approximately 8 months before. And the conversation in the WhatsApp messages really contained negative, derogatory, and sexist comments about other employees, including a female employee that we refer to as Miss A. The comments that were related about that pertained to Ms. A included comments about her exchanging sexual favors for career advancement. So Ms. A received screenshots of the WhatsApp messages and had made a report and had raised them to her supervisor back in 2019. She said she was upset by the messages when she viewed them, but she did not file a formal complaint at the time because she didn't want the matter to be investigated. When the employer became aware of the messages in 2020, as I mentioned, then it commenced an investigation. And in the course of that investigation, the employer became aware of additional inappropriate and sexual comments on the WhatsApp group chat. And ultimately, during the course of the investigation, Ms. A said she did not want to participate any further as it was causing her stress and distracting her from her job. So the employer nonetheless continued with the investigation and determined that the grievers had engaged in sexual harassment contrary to their policy, and they were terminated for cause. The union grieved those terminations, and the grievers were reinstated with back pay. The arbitrator, in ordering that reinstatement, stated that there was no harassment since the female employee did not make a formal complaint or participate in the investigation, and that it was therefore a conflict of interest for the employer to act both as the complainant, essentially, and the investigator. And the arbitrator had also found that the employer did not have a license to intrude on the griever's private conversations outside the workplace. So the employer sought judicial review of that decision. On judicial review, the divisional court held that the arbitration award was fatally flawed. It quashed the decision and remitted the matter back to a different arbitrator for reconsideration. And it's in its reasons for the decision, the court held that the arbitrator had failed to recognize, as Sarah explained earlier on, that employers in Ontario have an obligation to investigate workplace harassment even when victims do not wish to report the harassment or participate in the investigation. The court said it was wrong at law for the arbitrator to conclude that the matter should have ended when neither Ms. A, or frankly any other of the active employees who had been targeted by the WhatsApp group chat, that none of them wanted to file a complaint of sexual harassment. The court here specifically noted that an employer in Ontario has a statutory obligation under occupational health and safety to investigate both incidents, as Sarah mentioned, and not just complaints when those incidents are brought to their attention. This not only protects the victim, but also protects other employees in the workplace. The court here echoed, and you'll have it on the screen here, the Supreme Court of Canada's long-standing caution, and said that it's an error to rely on what is presumed to be the expected conduct or reaction of a victim of sexual assault, and that a victim's reluctance to report or complain about a sexual assault cannot be viewed to draw an adverse inference about her credibility. So you see here that the reference and the caution from the Supreme Court of Canada is related to sexual assault. And here the divisional court adds, in my view, there is no reason to limit this caution to sexual assault grievances. The caution about these types of presumptions and stereotypes applies to all sexual harassment grievances. So again, a victim's reluctance to report the complaint or complain about the harassment could be due to a number of factors. So here, the divisional court, as I mentioned, concluded the award was unreasonable, quashed it, and then the union applied for leave to appeal. Just 2 weeks ago, on June 6th, the Court of Appeal's decision was rendered, and it ultimately agreed with the divisional court. Here, the interesting excerpt that we have for you on the screen is really related to the myths and stereotypes that we're trying to challenge and remind ourselves to challenge. So the arbitrator's focus on the absence of an official complaint by Ms. A is based on a failure to recognize that there are many reasons why a victim of harassment might choose not to pursue an official complaint, none of which erase the harassing behavior or the employer's obligation to investigate in order to protect the workplace from a hostile or demeaning environment. The arbitrator erred by concluding that Ms. A's reluctance to pursue a complaint meant that there was no harassment. This line of reasoning relies on rejected myths and stereotypes about how an employee in Ms. A's situation would respond. So again, many reasons why complainants may choose not to file formal complaints, and that is not a reason to find that there is no harassment, and certainly no reason not to conduct the investigation. So I'm going to turn it over now to Sarah to discuss power dynamics in investigations.
So I wanted to address briefly a topic that we as investigators need to address and think about when we're dealing with issues of welcomeness in an investigation. So I think that it's true to say that when we are dealing with issues of unwelcomeness, we have to consider the role of potential power imbalances between the parties involved in that interaction. So, for example, where we have an allegation made against a manager or an executive by someone who, for example, reports to that person or is lower in the hierarchy of positions of that employer. And then what we're considering is where that person who's the subject of the behavior or the complainant hasn't objected to the behavior. They may have laughed at the banter back and forth or tried to deflect in some way. And I think it's true to say that when I started litigating and investigating these cases about 30 years ago now, a failure to object or going along with behavior was viewed differently than it is today and through a different light. And it was much more conclusive in terms of getting to what Judith was saying, sort of myths about how people would respond. But I think here we have to look closely and consider that power differential between the individuals and how that impacted a situation, or our investigation won't be as complete. So I think it's true to say that courts now are recognizing that where one person has power over another in the workplace, the ability to consent can be compromised, and the relationship or the interaction may not be necessarily voluntary, because this power imbalance will play a significant role in response to the unwelcome conduct in certain circumstances. It can impact someone's ability to resist or expressly state that the conduct at issue is unwelcome. And as Judith has already discussed, that failure to object or even participation in a particular behavior does not necessarily mean consent. I think that this is one of those principles where we need to keep it in mind. It's not always the case, and it doesn't always dictate a particular conclusion, and we do need to explore these issues. But it's very important to consider this power balance, imbalance issue when we're considering these issues. And there have even been cases where relationships that have started as clearly consensual come to an end, and then an employee will allege that the relationship after was something which they viewed as a condition of employment or where they received adverse treatment because of the power imbalance. So, as I said, this is an issue that we need to be really aware of. And, one of the things we can do is, especially where there is a power imbalance, we could ask the party who's alleged to have engaged in the behavior what steps they took to ensure that the conduct was welcome, given the relationship between the parties. And there was one case that basically stated the greater the power imbalance between the parties, there's a greater onus on the individual with the power advantage to ensure that the conduct was welcome. So I thought that was an interesting point in one of the cases. So again, this is just a quick reminder of something we should not disregard when we're analyzing these situations. And then to finish up, I want to address briefly the issue of artificial intelligence and investigations. And as we all know, we can't turn on the television, read an article about workplace or the future of work, or read a news account without hearing about artificial intelligence multiple times a day. And as we would expect, and we're reading about all the time, it's infiltrating the world of work. And that, combined with the fact that over the last several years, we've seen a greater focus on culture and governance in workplaces, legal requirements about investigations and what they should look like, we're seeing an increased number of investigations. And so employers and other organizations are starting to explore using AI while doing these workplace investigations. And of course, there's some risks and benefits associated with this. And as we're really at the beginning of using this technology in this context, but I wanted to bring to your attention a few points. The basic bottom line is AI needs to be used very carefully and with recognition of privacy and data protection concerns, as well as a recognition of the importance of human oversight and judgment in these matters. So when I started doing investigations many, many years ago, we always used to say that you'd bring the 3 Ps to an investigation: pen, paper, and patience. So now with the idea of AI, we still need patience, definitely, but maybe the idea of pen and paper is going the way of the dinosaur. So one potential use that I've seen discussed when it comes to AI is the idea of using the AI automated note-taking functions. We all know that we need to document our interviews, because that's central to our gathering and processing of evidence and considering evidence. And in many cases, when we do investigations, we have someone else sit in with us and we'll both take notes. So at the end, we'll have a complete set of notes, and you may or may not have a statement created or a summary, which you then get parties to approve of. So one of the things that's being considered is, do we use an automated note-taking function? It would free up resources and administrative time. It could have arguably better accuracy than a human taking notes, and could lower costs. But there are some issues to keep in mind. Automated note takers can misinterpret speech. I mean, we've all had issues with technology failing us when it's least convenient. So they could misinterpret speech. There could be pieces that are not heard if there's background noise or technical jargon, for example, that's being used. And I think it's important to note that we couldn't just rely on the notes that are produced through one of these technologies. Human review is going to be very important to make sure that it is accurate, and your same procedures in terms of verifying the accuracy of a particular statement would need to be followed. The other issue to keep in mind is, what are your current thoughts and processes around recording interviews? If you're an employer who does not allow or does not yourself record an interview when it's taking place, and you don't allow the employee to record the interview, how is this potential use going to relate to that policy? Are you really just doing the same thing that you don't allow in terms of a recording, using some sort of recording device to take down the sound? Or is this more akin to just a note taker sitting in with you? So those are some of the issues that the idea of note taking brings up for us. The other issue is document review. So there's some discussion about using AI technology to identify things like keywords, date ranges, identify relevant company policies, for example. But again, that has some inherent issues as well. Especially, I've been reviewing some articles where people who have been using AI in this capacity find that where an investigation is particularly complex and involves multiple different issues, AI is challenged in terms of identifying relevant documents, for example, when you need to consider nuance or something more subtle. And again, in any review that's created by AI, human review as to accuracy is going to be very important. I wouldn't, for example, rely on an AI report of documents that are relevant without myself verifying that it's not discarding things that may well be relevant. One area that is potentially less controversial is the whole idea of just using these tools for drafting. So creating summaries, drafting template documents, like investigations, meeting notifications, or some basic documents like that, compiling lists, witness lists, interviews, interview dates, birth dates, things like that. So pulling using them for basic drafting tasks. So in that area, I think that's where we're seeing most of the uptake of AI at this point, as opposed to the more sophisticated tasks where they're identifying contradictions, for example, in evidence. But that's another potential use. Again, when we're talking about any of these technologies, the important thing to remember is AI is not a substitute for human decision making. Although we're in the infancy of using this now, you can see in the future that questions could be raised about how AI was used in a particular investigation, where a party may want to question the methodology or the conclusion that was reached in that investigation. And any investigator is going to have to show that they themselves considered all the material evidence and that they, using their skills and their judgment, evaluated the evidence and made the credibility decisions so that they could defend their decision-making process if challenged. The other key piece to keep in mind here is our obligations regarding sensitive and confidential information, privacy, and data management issues. So, of course, any sort of personal data or confidential information should never be entered into any kind of publicly available generative AI tool, or where confidentiality and privileged information or that type of sensitive information is not protected. So what we see is organizations using tools that were either created specifically for them, that have no public function, and over which they can control the confidentiality and know that these interests are protected. So that's something to keep in mind, definitely. There's also the issue of AI hallucinations. I'm sure everyone's heard about this. From a lawyer's perspective, these are what result in the nightmare situation of people filing briefs, citing cases that don't exist because some AI product has created a hallucination of a particular case. Of course, that issue is taken care of if there's appropriate oversight and checking of work and the human judgment is still involved. But it's important to recognize that there are weaknesses and issues with some of the tools. And then lastly, there's the potential issue of bias. There's been some studies that have talked about the biases that reflect the products and biases of the material that's entered into an AI tool, and that could ultimately affect the output of using these tools in an investigatory capacity. So just before we end on here, I think the basic point here is workplace investigations, even using these types of tools, require an individual investigator's reasoned judgment, the application of their particular knowledge, experience, and skill. As I said, you as the investigator are going to have to show that you considered all the evidence and reached an objective and transparent outcome. There are ways that AI can help make the process more efficient, but it is not a substitute for our own judgment as investigators. The administrative tasks and some initial drafting, I think, could be very, very useful. But again, it's not a substitute for our judgment. And recently, I've been assisting a client developing some guidance for its investigatory team about how AI tools could be used. Because if you want to defend an investigation where AI is used and it's called into question in the future, having guidelines and training as well for those investigators who might be using this material would be very helpful, I think, in addressing those types of questions. And it will also just set expectations for those who may be using the tools as to how they're to use them and how they're not to use them. So that, again, this importance of an individual's judgment, experience, skill, credibility assessments is not taken out of the process while we're trying to increase efficiency. So I see we have a few minutes left for some questions. We got a lot of really good questions before the session started, and I see we've got some in the Q&A. So one of the questions that we had earlier, Judith, I'll send your way. It's basically, someone asked, how do we deal with parties who refuse to participate in an investigation? Could you give your thoughts on that?
Sure. Well, I suppose there can be many reasons why a party may be refusing to participate. So I think at the first step, we would want to think about why. Why are they refusing to participate? We discussed in the course of the presentation that many complainants may fear participation because of fear of reprisal. Whether they're concerned for career advancement or frankly just creating issues in the workplace with their workplace relationships. So in my experience, when I've had a complainant who was hesitant or refusing to participate in the investigation, I've found that, kind of like a reassuring discussion with them in terms of their protection from retaliation was really helpful, kind of explaining to them that the policies and the law protect you from retaliation. If you feel at any point that you're subject to retaliation, you can reach out to me. You can reach out to human resources within the employer. I've found that, after one or two of those discussions, I've generally been able to get the complainant on board in terms of their participation. I suppose anybody could choose to refuse just because they don't want to collaborate. If that's the case, then perhaps you have internal policies that you can look at, or even a collective agreement. If you are in a unionized sector, you could look at any type of contractual language that provides that your employees must participate in good faith in workplace investigations. And if that's the case, point your parties or your witnesses to that language and explain that the failure to comply with that duty may lead to disciplinary measures. So that could be another way. If you have a respondent that's refusing to participate, you could explain to them that the investigation is going to continue in any event, whether they participate or not. And if they choose not to participate, then unfortunately, the investigation will proceed without their version of events and their opportunity to present their facts and documentation. So I think those are all some strategies that the employer, that the investigators can take, whether internally or externally, in terms of trying to get people on board in terms of their participation.
Great, thank you. And Rebecca, I'll send this question to you. This is a question that was raised about, as an investigator, what do you do, or do you have suggestions when faced with a bad faith or frivolous complaint? Could you give me your thoughts on that?
Of course. So that's an interesting question. I guess when we say that a complaint is made in bad faith, I think it's important first to reflect on why we're saying that. So are we saying that the complaint was ultimately unsubstantiated at the end of the day? Or are we saying a complaint was made in bad faith because that is a determination we make during the investigation process, like perhaps somebody is lying? And so I think there's all sorts of reasons why, in the cases of an unsubstantiated complaint, why a complaint could be unsubstantiated. Often, we find that someone may have an honest belief that certain actions of an individual constitute misconduct, but then when we conduct an investigation through an objective lens, we find it's not ultimately founded. It could be that a complainant's memory was flawed, or they're thinking differently, or perhaps the complainant is truly exaggerating or telling a version of events that's self-serving. But I think in my experience, an unsubstantiated complaint does not automatically equate into a complainant who's intentionally lying or bringing a complaint in bad faith. And in fact, I think to characterize a complaint as bad faith is an extraordinary step. And so if we say that and we're wrong, particularly if an organization is then disciplining the complainant, the organization has left itself vulnerable to a potential charge or claim of reprisal. And so I think it's worth highlighting that the test for bad faith is a very, very high bar to meet, and probably based on the high number of cases that have been investigated, only an inconsequential number of those will ultimately properly fall in the category of bad faith. And so I think If you ultimately find in an investigation process that a complaint has been made in bad faith, you really want to be 100% sure, because that is a very, very serious conclusion to make. And so you'll want to make sure, in your investigation report, you've fairly evaluated the evidence, that you have evidence to back up that conclusion, and that the finding of bad faith can ultimately be supported, because you don't want to be faced later with a complaint of reprisal. And so I think it's going to be a very inconsequential number of cases where this actually occurs, but just highlighting that it's a very, very high bar to meet.
Okay, great, thank you. And I see we're almost out of time, but Judith, I'll send another question your way. That was one of the questions that we received from an attendee. What do you do when you're conducting an investigation and an employee who you need to interview is on sick leave?
Yeah, I think the first thing you want to consider is, what do you have in terms of medical documentation? I think it's going to depend on the circumstances, but naturally, if you have a medical certificate that is saying that the person is medically unfit to participate in the investigation, from a procedural fairness standpoint, you will not force them to participate. Obviously, if they're unwell to work, it's very possible that they're unwell enough to participate in the investigation. We see that sometimes with arbitration hearings, right? If you're unfit to work, then you're unfit to attend as a party and a witness. So on the other hand, we've seen some investigations that, especially in the context of workplace harassment, where the person may be off on sick leave, but still eager to participate. So I think in those circumstances, if the person is hoping to participate, what you may want to think about is actually getting a certificate that says that they are medically fit to participate, in case down the road they are unhappy with the result, perhaps, and then wish to contest it on the fact that they were actually not medically able to participate at the time that they were giving their evidence.
Thank you very much. Well, I'm seeing that it's now 3:30, so we've come to the end of our scheduled time today. I wanted to thank everyone for attending with us today. We had over 1,000 people in attendance, so we really, really appreciate it. There will be information in the chat or on the screen here about how you can obtain your CPD credits for Ontario, Quebec, and British Columbia. As I said, there are links also in the chat. And if you don't get a chance to claim your certificate today, they will be sent within the next week. So our Labor, Employment, and Human Rights Seminar Series is going to resume in the fall. As I said, we'd love your input about other topics you're interested in. If you want more on certain topics, please let us know. So thanks everyone for coming. Have a great summer and a great afternoon. Thanks very much.